As Stephanie's solicitor, I will be representing her in her claim against Michael, as well as putting forward arguments for the new tort of intentional infliction of emotional distress. The tort of Wilkinson and Downton, which has been clarified by many subsequent cases such as Wong and Parkside, Wainwright and Home Office C and D, as well as more recently O and A, in which the Supreme Court highlighted three important elements for this tort to succeed. The first is the conduct element, which refers to words or conduct by the defendant directed at the claimant without reasonable excuse or justification. The second is the mental element, which refers to the subjective intent imputed to the defendant. As a matter of fact, if the defendant intends to cause severe distress that results in physical injury or psychological illness, which is the third element, the consequence. I would advise Stephanie that she has a very strong claim on the conduct element basis. For example, Justice Wright argued in Wilkinson and Downton that the willful act which must be committed by the defendant must infringe the right of personal safety. In this case, Michael's conduct and his words have infringed the right of Stephanie's personal safety by misinforming her about state of affairs which are not true, by giving her facts about Ahmed which are not true. He has infringed her right to personal safety because as a result of his conduct, she spent 2 days in hospital placed on sedatives. She had to cry, and she cried uncontrollably. She had a ventilator. She was unconscious. So he infringed her right to personal safety. Similarly, Lady Hale, in the case of O and A, argued that in terms of the conduct element for conduct and words without reasonable excuse or justification, it may be argued by the defendant that it was a joke. Therefore, it's not actionable. However, in describing Wilkinson and Downton, which was similar to this case because it also involved a practical joke, Lord Neuberger described that practical joke made by the defendant as an unprompted statement made by the defendant that was inspired by something close to malice. So describing that practical joke as malice, it can be seen in this case that Michael's joke is also out of malice, and thereby he has caused, through his conduct, something which is not reasonable or without any justification at all. Similarly, his conduct is not acceptable because it is also related, these facts in this case is also related to another case, which is Allen and City and Hackney, HA, where the doctors, due to their conduct, which was misinforming the mother about the death of the baby, which was not dead, it was alive. As a result, the mother suffered PTSD. So they gave her misinformation about the fact that the child died, even though she didn't. Similarly, in this case, the defendant Michael has informed Stephanie about state of affairs relating to Ahmed, which is not true, and therefore he should also be held liable because he did something without reasonable excuse or justification. Similarly, Stephanie has also a strong claim for the tort in Wilkinson and Downton because of the mental element. Lord Hoffman, in the case of Wainwright and Home Office, affirmed that the intent to cause harm can be imputed to the defendant if it's an obvious consequence of the deliberate act, even if such harm is not subjectively appreciated or intended by the defendant. This means that Michael, even if he subjectively did not appreciate or intend the fact that through his conduct or his words, Stephanie would experience that obvious consequence, or the fact that she would experience distress, hyperventilate, cry uncontrollably, and go to hospital, it doesn't matter. Because through his words and through his conduct, what she experienced was an obvious consequence. Because if Michael has informed her about an untrue state of affairs and Stephanie experiences a negative reaction, this is an obvious consequence to his action, even if he did not subjectively appreciate this or intend this. Similarly, if Michael argues that he intended this as a joke, he did not intend to cause serious mental injury or psychological illness to Stephanie, this claim can be argued against by using the argument made by Lord Neuberger, who argues that the defendant in Wilkinson and Downton merely intended the statement as a joke, but the fact that he intended as a joke is not inconsistent that it was intended to upset the claimant. This means that in this case, even if Michael has intended to joke with Stephanie, the fact that he has intended to joke with him is not inconsistent with the fact that he has intended to upset the Stephanie, and through his conduct, she was upset, she was crying uncontrollably, and she had to be taken to hospital where the doctors told her she suffered a panic attack. So it can be argued that the conduct element is very strong in this claim, as well as the mental element, because it can be argued that intention can be imputed to the defendant because of the obvious consequence to his actions, even if he did not appreciate this. However, Stephanie's claim might not succeed. It is weak because of the consequence element. The case of Wong and Parkside states that there has to be actual damage, and the actual damage has to be physical harm or psychiatric, a recognized psychiatric illness. Similarly, the case of C and D, in which Lord Field argued that Wilkinson and Doughton is only available if the harm is a recognized psychological injury that does not allow recovery for emotional distress. Similarly, in the current case of O and A, the Court of Appeal argued that where the defendant has the intention to cause serious mental injury or psychological harm, that is only the case that if it results to a recognized psychiatric illness or physical harm. In this case, it might be argued that she will not succeed in claiming damages due to the consequence. What she experienced is not akin to a psychological injury, because Harvey Teff argues the normal human emotion and the normal physical consequences, however stressed, are not deemed either psychiatric illness or physical injury. Moreover, in the case of Vernon and Bosley, the Court of Appeal argued that damages for mental injury do not include compensation for feelings of grief and bereavement, which are not themselves symptomatic of illness. Similarly, in the case of Wainwright and Home Office, Lord Hoffman argued that the Wilkinson and Downton tort doesn't provide remedy for distress which doesn't amount to recognized psychiatric injury. Thereby, her claim would not succeed because her experience of the distress would not amount to psychological injury, even if she affirms the mental element and the conduct element. There are many reasons why the court should adopt the new intentional infliction of emotional distress. For example, Lord Hoffman, in the case of Wainwright, argued that he does not recoil from the position that recoverable damages in negligence do not also apply equally to torts of intention. This means that if someone intends to cause harm and the claimant suffers from distress due to the defendant's conduct, there is no reason why the claimant should also get compensation. However, Lord Hoffman did wish to reserve his position, and he argued that it's challengeable that the claimant should get compensation for feeling distress. This is because in institutions and workplaces all over the country, people do and often say things with the intention of causing harm. However, it's not appropriate, according to Lord Hoffman, that they should be dealt with through litigation always. Nevertheless, he did not rule out the claim that a person can get compensation due to experiencing distress due to the defendant's conduct. In addition, Lord Neuberger, in the case of O&A, also was willing to extend the liability in liability in Wilkinson and Downton under Wilkinson and Downton to cover cases which only deal with pure distress. He argued it was possible potential claimants can get compensation by claiming that they suffered significant distress. It was enough for them that they claim significant distress, and that is it. He argued that there is much to be said. He argued that there is plainly a powerful case. Nevertheless, he did criticize this position. He argued that it's important that not to allow the tort to undermine the freedom of expression, to define this tort clearly, and not allow the tort to be used to extend or supplement the law of defamation. Similarly, on the other hand, it may be argued by the court that they do not want a new intentional infliction of emotional distress tort because it would lead to on public policy grounds. Because if a claim is allowed, if the courts allow a claim to go through because of the stress they experience, this would lead to floodgates, which would lead to more frivolous and more fictitious claims. Nevertheless, William Prosser, in his article "Intentional Infliction of Mental Injury," argued that it is the court's duty to differentiate those claims in which the claimant have been wronged from those fictitious and fraudulent claims using the matter of proof. In addition, the court should accept the intentional infliction of emotional distress because medical science, according to William Prosser, as he argues, recognizes that shock, fright, anxiety, grief, and different forms of emotional distress are physical injuries because they produce well-marked changes in the body, and such consequences are the normal rather than the unusual result of threat of physical harm. So even mental injuries can result to the body injuries. Similarly, mental suffering is scarcely more difficult if it is argued that a person cannot. If it is argued that it is difficult to measure the damages in terms of emotional distress, nevertheless, mental suffering, as William Prosser argued, is scarcely more difficult of proof and no harder to estimate in terms of money than physical pain of broken leg, which never has been denied compensation. So if a person can get compensation due to a broken leg, he should also be able to receive compensation due to the mental pain that he has experienced, and it is a seriously wrong, and it is a claim that where he has been seriously wrong. And these are many reasons why the court should accept the new tort of intentional infliction of emotional distress.